Greetings, Attorney Derek DeBrosse here, Munitions Group, munitionsgroup.com. As always, go ahead and like us on social. Go ahead and click the little bell icon. Make sure you follow us on YouTube. I'm coming back to you with some updates today. First off, on restoration of rights. As you guys know, we follow this very closely. We're gearing up, getting ready for that. And I've been trying to pay attention to it. Nothing new, really, at this point in time. We're still waiting for the final application from the federal government. Again, this is for federal restoration processes and for the rule to be finalized regarding the same. So we're going to keep an eye on that, keep you guys in the loop. I did see something in the news today that I wanted to get on YouTube and drop a quick video about, and that was Snope versus Brown out of Maryland. This came, I believe, out of the Fourth Circuit. Don't quote me at that. Real quick, see if I can find it. I cannot, but I believe it's the Fourth Circuit. Anyhow, was up on a request for cert to the U.S. Supreme Court. U.S. Supreme Court recently denied that, I believe along maybe with one out of Rhode Island as well. But essentially what this case dealt with was after some active killer situations, I believe the Sandy Hook case in particular, Maryland passed a gun law that basically banned AR-15s or similar style weapons. So the question before the court would have been whether or not this is constitutional under current Supreme Court case jurisprudence. Just to kind of bring you guys back up to speed, just briefly here over the years, obviously modern jurisprudence in the Second Amendment started with, in my opinion, the bulk of modern jurisprudence started with the Heller decision out of D.C., and Heller stood for the proposition the Second Amendment is not a right relegated to only the militia or what we call a collective right. It's an individual right that's entitled to all of us individually. And then the McDonald case out of Chicago a couple years later held the premise that the states are also subject to that same analysis, and basically the Second Amendment is what we call incorporated to the states. And then we have the Bruen decision that came out a couple years ago, and Bruen basically stood for the proposition that we do not use interest balancing. So we don't say, well, is Maryland's gun regulation in light of public safety necessary versus the restriction on our individual liberties? In a lot of constitutional areas, that's kind of the basic analysis that courts will undergo, and that's what they started to do, actually, the Second Amendment. Although if you go back to Heller, Scalia made it very clear that interest balancing was not something that we were supposed to do with regards to the Second Amendment. So Bruen said, nope, that's not the case. And in fact, what we're going to do is look at the regulation and decide, is there a historical tradition of an analogous type of law from a historical and traditional perspective regarding the gun regulation at issue. So what Maryland basically did is the court in the Fourth Circuit basically held that, in fact, these laws were constitutional and in line with history and tradition. What's interesting here is that a couple of justices, actually, Kavanaugh and Thomas, actually wrote basically dissents on not taking cert, in particular Thomas. And Thomas basically, and let me back up for a minute, Kavanaugh essentially said that, hey, he's indicating or telegraphing that this issue is going to come in front of the Supreme Court. That's what all the headlines are saying today. Do I know that for certain? No. Do I hope the Supreme Court addresses it? Yes. We have tens of millions of people that own AR-15s in this country, and if they're not protected by the Second Amendment, that's obviously of real concern. With that said, Snope versus Brown, again, dissenting. Thomas made some good points, and I just wanted to bring that up. If you guys have a chance to read it, I would encourage you to do so. And just a couple things here. Thomas, and I'm reading, that's why I'm looking down. Thomas stated that Maryland invokes the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Under this tradition, however, a weapon may not be banned unless it is both dangerous and unusual. Weapons in common use today for self-defense and other lawful purposes remain fully protected. One of the arguments that the state of Maryland made was that, if we take that to its logical extreme, if people start to regularly use nuclear bombs in common use, they become lawful under the Second Amendment. And Thomas quickly debunks that, even in this small dissent regarding certiorari, or the application for the court to accept to hear the case. And he basically said that's just not realistic. We don't see a world where people are going to start using nuclear weapons against each other in self-defense. It's just not a very practical stance to take. Additionally, what he is quoted as saying here, despite the foregoing, the Fourth Circuit, I was right, it is the Fourth Circuit, upheld Maryland's ban on the ground that AR-15s are, one, not constitutionally protected arms under the plain text of the Second Amendment. The court acknowledged that at first blush, it may appear that AR-15s fit comfortably within those terms, but the court insisted more is actually required. This is where it gets a little interesting. Because the Second Amendment must be interpreted against, he's quoting now the Maryland Fourth Circuit, because the Second Amendment must be interpreted against this historical and legal backdrop, the Fourth Circuit held that the challengers also had to show that, quote, the right to possess, not merely, we're no longer addressing the regulation itself, we're addressing the person's right to possess AR-15s falls within the, quote, the historical scope of the right to keep and bear arms. The challengers could obviously not make this showing in the court's view because the Second Amendment does not protect the right to own dangerous, unusual weapons. Found that very, very interesting. I did peruse through the Fourth Circuit's case and believe that, Thomas is obviously right. This is of concern to all gun owners that have AR-15s. There was several justices that would have heard this case if the court had accepted it. They wanted to hear the case. It's been telegraphed now by a couple justices out of this case that they anticipate that it will be heard. Obviously, right now, the Fourth Circuit, the AR-15 ban out of Maryland is constitutional at this point in time, at least. So we'll see what happens. Stay tuned. We'll try to keep you guys updated as much as we can. Remember, as always, be safe and carry on. And if you have any comments, please drop them down in the comment section. We'll try to get to any questions you guys have. Take care.